you hear me at all?
I can definitely hear you.
It's mine. Okay. All right. Who knows?
Is it telling you that we're live yet? Because we are live.
All right. Well, so here we are, folks. It's Monday. Welcome back to Law and Legitimacy. And of course, we'll want to know, before we discuss the events of the day, how did the objectors do in our fantasy football league? Ask Lawyer Will. Lawyer Will, if you're out there, I know you were a 10-point favorite in the projections, but the objectors did come forward, thanks largely to Nico Collins' standout performance. And Josh Allen, of course, didn't fumble this week, but threw for almost 300 yards and 3 touchdowns. Mike will be quick to point out, don't get too comfortable in the win column, because Mike's team continues to rack up more points than anybody else. Even his bench is impressive. And so I look forward to week 6. Sort of.
I'm just glad that I caught Dawn last week, because she has blown it apart this week. So if you go back and check her team name is SWAT Team, and she's swatting the hell out of everybody. So glad to have gotten a win under my belt against her in week 1. Good luck to everybody who she's going to rip through the next several weeks.
Well, we'll see. I'm not sure who I have next, but it's been great fun. You know, it's funny. I was in here over the weekend writing a brief, a certiorari petition to the U.S. Supreme Court, which is a fairly high octane thing to do. And yesterday afternoon, I turned the screen on, and I'm following my team, and I'm looking at the league in general, and I'm screaming at the screen while I should be checking cites to the Supreme Court. So I found myself sitting here thinking, wait a minute. Why do I care so much about this fantasy football team? And then, of course, I went to, why do I care so much about college football? And then, of course, I went to, why do I care so much about my cases? And then I went to, why do I care so much about this brief? And so it provoked an interesting philosophical discussion about what it is we choose to invest ourselves in. And I came back to the conclusion that I reached so many years ago in so many ways. And that is that when we're children at play, we're at our best. And Mike, thank you for instigating the creation of the Law and Legitimacy Fantasy Football League. Again, Lawyer Will, my heart goes out to you. I wish you better luck next week.
Lawyer Will isn't quite in the chat yet, but I'm sure when he gets in and catches up, he'll have a few words for you.
I'm sure that Lawyer Will is probably recovering, and probably he may not be able to face the scorn and ridicule that I might direct in his way. When he shows up, let me know. Oral arguments in the First Circuit Court of Appeals. So what am I talking about, First Circuit? What does that mean? Federal court system, 3 tiers of courts. There are district courts, that is trial courts. There are 94 districts in the United States. Some states, larger states, have multiple districts. Smaller states like Connecticut have but 1. There are 11 circuit courts of appeals. In other words, above the trial level, there is an appellate court. And those the appellate courts of the federal system are divided into the 11 circuits plus the D.C. circuit. So in the Second Circuit, where I live I do for almost all the time. The Second Circuit is Connecticut, Vermont, and New York. The First Circuit is New Hampshire, Massachusetts, and Maine. So and then above them, obviously, is the United States Supreme Court. So in the First Circuit Court of Appeals, the case of Foote versus Ludlow was argued last Friday. And this is a hugely significant case. Mike, what were they arguing about?
Well, apparently there is a librarian in this middle school. And the librarian at one point sent out an email to all the staff, teachers, and counselors at the school, telling them that she or he was transitioning and that they should now abide a new name and a new set of pronouns, and listed all these pronouns out and said that, I'm telling you this because I trust you, X, Y, and Z. Don't use the pronouns not listed. If you don't use it, I will verbally reprimand you, whatever. And one of the teachers, to that teacher's credit, decided that this was in the interest of her parents to know sort of what was going on in the school, and forwarded to her classroom's parents that email from the librarian. And the school terminated that teacher for... Yep. So that was sort of the first domino to fall in the fact pattern, as I can as I can tell. But that was the first domino to fall. The teacher was terminated because there was a school policy that said something to the effect that that I guess school emails could not be forwarded outside. Now, I think from a technical policy perspective, I can understand the intent there. But the school terminating the teacher for that purpose is, I think, more of the interesting corrective action taken. Fast forward to here, the school apparently does not have a formal policy, although the plaintiffs in this case allege that there is a formal policy of transitioning, that the school will allow a student to confide in his or her teacher, and that his or her teacher may opt to begin calling that student by a new name to shield such information from the parents and to only use that name within the confines of the school. And they can begin giving them resources and all sorts of other, I guess, therapeutic kind of treatment in the effort to help them realize or reaffirm or affirm their true gender identity. And in the case of Foot, their daughter, the 11-year-old daughter, was talking to the teacher about her concern for her lack of popularity, that she was somewhat depressed, having self-esteem issues, that she may perhaps be attracted to other girls. And rather than helping the student by way of talking to the parents and anything else to express and to communicate what's going on, the teacher began forwarding her into the direction of perhaps you're not a girl.
So, and all this without ever informing the parents about what was going on with the child?
Yes. So, and there are other parents and students.
It strikes me as outrageous.
Yes, I mean, it is. The whole thing is outrageous. And I'll put the complaint here. The original complaint is here on the screen. And Norm, as you said, oral arguments were held on Friday, September 15th. And I want to give a hat tip to Ron Coleman for sending this our way. He was the one that sent this to us, and his wife Jane is who is reporting on the oral arguments. And I do encourage you to go to legalinsurrection.com and find this. But it's amazing because this is not the only case of this type. And I think I was listening, Norm, over the weekend to a podcast from Tim Pool, and he had a couple of people on. There's a gentleman out of Texas who has now become an advocate for parents' rights, family rights, parents' rights, because his ex-wife has taken both of his daughters to California and is transitioning and treating them as boys.
Let's break this down. And well, I mean, I cut you off. Go ahead, Mike. Finish your thought.
And there's also, listening to the state of nature as it relates to the court system in America, what parental rights ultimately are, and how marriage, how the law treats marriage, is a real consequence to parental rights overall. And I say that from a perspective of the development of what's known as no-fault divorce. And how that has seemingly resulted in a cascade of more liberalized approaches that are ultimately inuring the state with just to wield power as against anyone and everyone when it comes to adjudication of parental rights and the rights of children.
So, these are related concepts, not necessarily. They don't necessarily entail one another. In other words, one doesn't necessarily flow from the other, but politically they're associated. But let's go to constitutional fundamentals. We have created a federal government, ostensibly, at least arguably, of limited powers, and the states have reserved certain police powers, and the federal government abstains from it getting involved in certain matters as a matter of policy, because these fall within the state's police powers. And police powers relate to health, education, and welfare. We recognize as a matter of federal law, and I think as a matter of every state constitutional law, that there are some rights that are fundamental. There are some things that are so important to individuals that we say the state can only impinge on them, can only affect them for the most compelling reasons. And so the law plays with a number of different legal standards for evaluating state action. One of them is so-called strict scrutiny. So if you have a fundamental right, the state can only interfere with it if its interest is compelling, and if the manner in which it interferes with this fundamental right is narrowly tailored and there's no real alternative. This question of gender identity has caught the law with its pants down, so to speak, no pun intended. And nobody quite knows what to make of it. But it would seem to me that it's obvious that the right to raise your child is fundamental. And the Supreme Court has recognized that before, Nebraska versus Pierce and whatnot, involving language teaching and other things in the home. It used to be controversial to teach your children German, for example, in the post-World War II area. And the courts recognize it in Yoder, Wisconsin versus Yoder, involving, I believe, Amish children and the rights of parents to raise their children in accord with their religious preferences. Can you force a child, for example, to stand to say the Pledge of Allegiance if that's against his or his family's or her family's or its family's values? And the answer is no, you can't. And that's because there are certain things that are off limits to the state. And as a policy matter, it used to be that we recognized the integrity and the centrality of the family in our society. Supreme Court decisions are filled with dicta, that is, language that is unnecessary to the strict holding of the case. In other words, what must or must not happen, and that say such things as the family is a fundamental unit of our society, and it is such that we cannot imagine our society without it. Well, guess what, folks? We are now in the midst of the great reimagining, and we are not just imagining a society without families. We're imagining a society without genders, and we're imagining a society without people who are what they were born to be at birth, but we're investing in people the right to reimagine and to remake themselves, including even minors. And so we're saying if kids that are too young to drive, too young to vote, too young to declare that they should be legally emancipated from their families, that they can be encouraged to decide to change their gender. And we've empowered the medical industry to remove body parts from children who make that election. This tendency in I guess it's the Ludlow School District in Massachusetts, to protect children from their parents when these children begin to experiment with gender identity, and the policy of the school district to interfere, or in the school district's mind, to encourage children to express identities and then not let their parents know about it, to me is a shocking constitutional development. And
and this is what makes it, in my opinion, so the original reporting on this stems back to 2022. There's the update in July of 2023, so just a few months ago. I'm going to read from that article on legal insurrection. I'll throw this on the screen just so that we can follow. But this what I have highlighted here is what I'm reading. In court, keeping kids safe overrides parental rights. When Foote and Silvestri challenged that policy in federal court last year, they claimed that withholding information about their children's gender identity violated their constitutional rights to direct the upbringing of their children and make medical and mental health care decisions for them, as well as their right to family privacy. But in December, U.S. District Court Judge Mark G. Mastriani dismissed those claims. The court ruled that the parents failed to explain how social transitioning, referring to a person by his preferred name and pronouns, had clinical significance as a mental health care intervention. Quote, addressing a person using their preferred name and pronouns, end quote, therefore doesn't violate the parent's rights. It, quote, simply accords the person the basic level of respect, the court held.
Well,
this is like 11-year-old kids. These are middle school aged kids, Norm. These aren't adults. These aren't 17, 18, 19-year-old people.
I mean, the problem with Mastriani's logic is if you're going to afford them that level of respect, then, what if they decide they don't want to live at home? I mean, usually, the emancipation decision means that a child, usually you become an adult at age 18. You can become emancipated from your parents earlier, usually by going to a probate court or a surrogacy court when you're 16, 17, maybe even 15 years old. And if you can demonstrate to the court extraordinary maturity, that is the ability to make decisions for yourself in ways that accord with a reasonable set of standards, you can be emancipated from your parents and declared to have the rights, as it were, of an 18-year-old. Not necessarily the right to vote, drink, or drive if you're under 16, but to make these sorts of decisions. No, I don't think any court has ever emancipated an 11-year-old. And it seems to me that one of the functions of a family, of a parent, is to guide a child through the rigors of childhood and early adolescence and maybe even late adolescence, to set them on a course of stability in going into the future. If my child's out there deciding that he doesn't know if he's a he, or she doesn't know if she's a she, or they're aspiring to become an it or something else, as a parent, I want to know about that. I want to know about the choices they're making, about how they express themselves. What's more, I want to know why the school system is engaging in these discussions with my children. I sent them there to learn to read, write, reckon, and accord themselves with the world of shared expectations. That's what an education is. It is the formation of character. I didn't send my child to school to have the school substitute its judgment for what makes a good life for mine. And if my child develops interests that are inconsistent with my values, then I'm going to have conflict at home. And how I learn to deal with that conflict with my child will help define that child's character. Some parents will be stern. Some parents will deny their children the right to make certain choices, and it will create conflicts in the home. Other parents will be more flexible. But that's a right a parent gets to make. The notion that a school board can make it independently of parents is chilling. And, I think this First Circuit case should go ultimately to the Supreme Court, because it's going to raise questions about the fundamental rights of families and of individuals. And it's going to do so in a way that's going to test the limits of individualism.
Well, and here I am again, extolling the virtues of our middle school public school system in America. Just how stocked with talented, competent, people of great aspiration it is. I think what concerns me about this is just this sort of pedagogical approach to something that none of these people are qualified to talk about. Not even the therapist that they would even have in the school. It is absolutely ridiculous that you can have a librarian that sends an email to everybody saying, "Now I'm non-binary and you need to abide these things," and as sort of the tipping point for saying that teachers in the school are supposed to be able to have private conversations with students who aren't even of age to, for anybody watching and listening, age of majority is 18 in the United States. In almost every state, Norm, I don't think that there's a single state in the United States that departs from this. You must be 18 years old to be deemed competent to consent to a contract, just a basic contract. And we are talking about affording schools at the middle school level deference to allow their teachers to have conversations about calling a student a name other than what their parents sent them to that school with, being able to indulge them about being someone other than who they are.
Yeah, no, I mean, I think it's outrageous.
Unreal. It is unreal. One last thing, and then we'll leave this alone, and we'll keep an approach to this, because I know that this is something that has people interested on YouTube and on Rumble. I want to read from Oral Argument. This is quoted in Jane Coleman's Legal Insurrection article. School's lawyer, quote, "If one accepts that gender identity," and this is the lawyer for the school talking, defending an oral argument. So the court wanted to know how the school justified its non-disclosure policy, given that it was not required by Massachusetts law. And a point that I think that lawyer actually agreed with and conceded. School's lawyer, quote, "If one accepts that gender identity must always be disclosed to parents." First of all, I don't even know what the hell that means, Norm. Like the first part of that sentence.
Mine was disclosed. My kid's gender identity was disclosed to me at birth. One kid had what, and the other one didn't.
These are not serious people. So if one accepts that gender identity must always be disclosed to parents, then there are any number of other important aspects of the child's life and personhood that must also be disclosed to parents. There's no limiting principle. They can't be required to pick and choose constantly which information gets shared back. It's just not tenable. I think, and to the court's credit, apparently the court didn't really give them refuge on this. But what an insane starting line for the school's lawyer. to say that if gender identity must always be disclosed, and what does that mean? First of all, the way I hear that, Norm, is that gender identity is not solid, it's free floating. And so there has to be constant refreshing updates, right, to gender identity. And because of that, there are just these infinite number of things that need to be disclosed to parents, which just isn't tenable. It's not tenable for us to just update parents when their child decides to be someone other than who they sent them to school being at home.
Well, it used to be that the Diagnostic and Statistical Manual of the American Psychiatric Association recognized gender dysphoria as a disorder. I don't know whether it's the new normal, but the fact of the matter is that confusion about gender identity is a real thing. But if ever there were a time that a child would need the love, support, care, and guidance of their parents, it would seem to me that it would be at that moment. And to take that away from the parents, to shield them from knowledge that their child is even having such issues, is to overturn the apple cart, in my view, and to give to a collective entity filled with middling talents, the middle schools of America, for the most part, the ability to shape the character of children in ways that undermine the significance of family. And that is a huge issue. I think that, the United States Supreme Court has made clear that it is a family's fundamental right to inculcate their children with values and to have a formative influence on their child. Dawn McNeil writes, I blame sociology for overdoing the distinction between sex and gender. Dawn, I think, is a defrocter, or at least maybe not defrocked, that's the wrong word, is a sometime sociologist who's left the profession, I believe. Maybe retired now because she does boast of playing pickleball during the day. But sociology, takes the position. Well, sociology was a science created in the 18th century, and it was designed in the 19th century, it blossomed. And it was designed to say that if we can know the world and manipulate it, and if we can make things, maybe we can make better people too, by restructuring the way in which they are raised. And so people become encoded with names, with roles of sociological significance. And the great conceit of sociology was that we can build better people the way we build better cars, and that human nature was infinitely malleable, and a better society, better managed society would make better people. The chickens have come home to roost. And we see now that there's something about the human character that is immutable, in my view. Philip Roth might have called it the human stain. St. Augustine might have referred to it as original sin. The fact of the matter is we're more than what we are in the world as a set of signs and tokens that we share in public. We have character. And that character is individual, and that character requires difficult choices and reckoning with the world around them. So the sociological imagination has transformed the world into a dumpster heap, in my view. And we are now in the throes of something called expressive individualism, where we are seeing its extreme expression in the schools, where we've got 10 and 11-year-olds telling us what they are. It used to be that the process of going to school was where you could learn who you were by reckoning or measuring yourself against a wider world with standards. Now we say to the child, you set the standards and we'll bend the world to your will. This is sociology run riot, and it's a vision of the collective good that suggests that we can all be whatsoever we want to be. We'll talk more about that later. I actually think it has to do with the fact that many people are not engaged in producing things in the real world. So they focus now on the production of themselves as an entity. But that act of
social media, Norm, social media,
yeah.
This is going to tie back into it whether we want to or not. All roads are going to lead to this because young people are on these platforms, and that is how they have access in this disillusionment from grading themselves in contrast to what they're seeing fed to them online.
We will talk more about that. The world has changed and the algorithms are not making it better. Let's shift quickly. Mike, I got a hard stop at 8:30 today. I'm in the appellate courts again this morning, and I got to be on the road. But yesterday, the Saif Khan made national news. It was reported in the New York Times and then went to the Boston Globe and New York Post and the Guardian and papers in Pakistan and everything else. It involves a case named Saifullah Khan, a guy named Saifullah Khan. Spoiler alert, he's a client of mine. And so in 2015, he was accused of raping a classmate one night at Yale. His contention was that it was consensual sex. We went to criminal court, and the state of Connecticut tried him for sex assault. There are 4 variants of sex assault in Connecticut. They said to the jury, we can't really figure out which one it is. You guys pick. The jury did. Not guilty on all 4 counts in just a couple hours. We then turned around and sued Yale. And we sued the complainant too, Jane Doe. We haven't named her publicly, at least not yet. And the suit was based on the notion that, he was falsely accused of rape, and it damaged his reputation. Now, we didn't sue Jane Doe for what she said in court, because the law is absolutely clear. A person testifying in a courtroom is immune from civil litigation. We sued her for what she said to Yale in administrative proceedings. Her lawyer took the position that this was a quasi-judicial immunity, that Yale's proceedings were so much like a courtroom that the immunity that applied to a witness in a courtroom should apply there. We said, no, it's not. He didn't have a right to a lawyer. He didn't have the right to cross-examine her. He didn't have the right to call witnesses that he wanted to. He didn't even have the right to be present in the room when she testified. And there were all sorts of reasons in which the Yale administrative process, which is steeped in Title IX requirements, so fundamentally lacked the indicia of reliability that it should not be called a judicial proceeding at all. We took that issue up to the Second Circuit Court of Appeals. They said that's a state issue, the Federal Court of Appeals. So we asked them to certify the question, that is, to ask the Connecticut Supreme Court to decide it. The Second Circuit did. The Connecticut Supreme Court ruled 7-0 that we were right, that Yale's proceedings were, and I don't think they used the words, but I doubt that they disagree with it, effectively a kangaroo court, that were so lacking in reliability that you couldn't call them quasi-judicial, and Jane Doe could in fact be sued. The case is sitting in the Second Circuit yet, where they're trying to decide what to do with the Supreme Court decision. We expect a remand to the district court any day, and then discovery will begin, and someday over the rainbow there'll be a trial. But the significance of the case is simply this. We have a university set of procedures that treat campus sexual assault claims in such a way that they give the presumption of believability to the victim, the alleged victim. And nowhere else in American law does a person get the presumption that just because they complained, they're right. And so Saif Khan was held out to the world to be a rapist, and he was acquitted. And then the university still threw him out anyhow because they chose to believe the victim, and they chose to believe the alleged victim in the context of proceedings that can most safely be described as a joke. And so we're delighted by this. Mr. Khan is going to press in the litigation going forward to have Jane Doe's real name used. And there'll be enormous pushback from Yale, and there'll be enormous pushback from Jane Doe. They'll say, but she's a victim. And I'll say, no, he's the victim. He was called a rapist. He was thrown out of Yale. Saif was a young man whose family in Afghanistan, many members of his family, had been murdered by the Taliban. He was being raised in a Pakistani refugee camp where he was found to be a brilliant child, and Yale talent scouts, as it were, spotted him and lured him to the United States with a scholarship. Before he attended Yale, he went to a boarding school as he put it, to learn to use a knife and fork. And then he was going to take the world on. Well, Yale promised him the world and then threw him out on the street like a piece of garbage because they ended up in the thrall of the Me Too movement. Who pays for Mr. Khan's future now? So we sued Yale for $110 million. Good luck, you say? Yale's got it. They've got an endowment that's larger than the state budgets of many states. And we intend to take a significant piece of it to compensate him and to send a message that if you're going to complain about somebody, you better be right. Because if you ruin their lives, your life is going to be at stake. Now, that violates the American rule in some respect. We say that the American rule is each party bears their own costs. Well, that's true. But on the other hand, while you may enjoy the judicial privilege for your testimony in court, you don't enjoy it for how you defame a person elsewhere. And in the case of Saif Khan, his reputation was ruined, his prospects destroyed by a woman who we claim made false claims. So take a look at the story. It's an interesting read. The Times got it almost all right. They said the case is pending now in the district court. It hasn't made its way back yet. It's been about 6 weeks since the Supreme Court ruled. We don't know what's taking the Second Circuit so long. I have some apprehension that they're trying to find yet another way to hurt Mr. Khan, but we'll know soon enough.
Well, I was going to pivot to the UAW strike and one Barack Obama's just really nice post on X, but instead, I think because of your hard out, I'm just going to pivot to this and ask, if anybody sees my F-35, I lost it. I ejected as I was taking off somewhere over North Charleston, and I'm fine. I made it to the ground safely, but we still haven't found my jet. So if you see my jet, please call me. Thanks.
What up with that?
We'll talk about this more tomorrow, but I basically just gave you the facts. It's I think a Marine aircraft squadron out of Charleston, South Carolina. Plane took off, pilot ejected over North Charleston and is okay. The plane has not yet been found. So I don't know what to make of this right now. I think I told you, Norm, that my initial assessment that was perhaps we were just using this as a way to boast that now we don't even have to put pilots on our planes. They just kind of do what they want. But who knows where the hell it's going to go?
Well, listen, folks, tomorrow I'll report from Manhattan. I was retained over the weekend to assist in the defense of a young man who was accused of criminal mischief. What did he do? Allegedly, he defaced a George Floyd statue. So this should be a good time in New York. I'll report to you on it this week, presumably on a day-to-day basis as trial unfolds. Thanks for listening to Law and Legitimacy. How do folks find us, Mike?
They can find us right here on Rumble Video, YouTube Live, or on X at LawPod Daily. We're here every day, 8 a.m., broadcasting live. You can always catch our streams in audio-only form on Apple Podcasts, Spotify, Google Play, Overcast, Audible, etc., wherever you find podcasts. So please rate us 5 stars and leave us a nice comment, or what, Norm?
Leave us alone.
All right.
Now, I'm on my way to the Connecticut Appellate Court, where we're going to argue one of Alex Jones' issues with the trial judge in the Sandy Hook case. She held him in contempt for not showing up at a deposition. His doctors had sent him for medical treatment. Who would you trust with your medical care? A judge who has a little bit of a bias against you, or your doctor? Let's see what the appellate court says today, shall we?
See you tomorrow, Norm. Thank you, everyone.